Today, Mr. Schmidt.
Judge, previously, at Mr. Gerard's request, I thought motion to withdraw in court evaded the motion pending the outcome of the competency evaluation that's been confirmed, and re-urged my motion to withdraw at this time at his request.
At Mr. Gerard's request.
Yes, sir.
Mr. Gerard, are we still having a concern?
Yes, I'm getting an attorney out of the office, and I'm in correspondence with him right now.
Okay, who are you hiring?
I have a couple I'm talking to.
Have you?
When they come, I'll sign one to the docket.
Okay.
They'll sign one to the docket.
Can you tell me who it is that you've spoken to? Like,
No, sir.
do you not know their names, or?
I can't remember. I really can't. All right. So last time, I didn't even get to come into court. Y'all didn't even let me come into the courtroom, and then y'all sit back.
He's allegedly hiring an attorney, but can't remember any of their names? If you're facing serious charges and your legal strategy starts with, "I forgot who I'm paying," that's a giant red flag. Viewers, what do you think? Is this forgetfulness or finesse?
To myself to come to court today after I bonded out. Last time I walked in court with him, we were supposed to be talking to a specialist. And then I walked in, we're doing a docket call instead of talking to a specialist. And I don't know, are we at a docket call right now? What are we doing today?
We were at a couple things. We were at a docket call and then a status on the report for the doctor that you met with.
Right.
Classic courtroom contradiction. I'm not crazy, but everyone's out to get me. Remember, competency evaluations aren't about calling someone insane. They assess if you understand the process and can assist in your own defense. Spoiler, fighting the shrink doesn't help your case.
Well, he's a head shrink. I don't need a head shrink.
I understand.
I'm not crazy.
I know, but
I know you need it for court.
I do need it for court. That's
I need
exactly
a
right.
specialist to evaluate the surveillance, and they lost the phone that was supposed to be introduced into the case.
I know. And Mr. Smith,
Like a little sloppier than I was introduced, so I want him to get in and reorganize everything.
okay. And Mr. Smith has brought all that up to the court. And yes, I'd ordered the psychiatrist to interview you to give me a report, and that report has come back. The problem that I'm hearing, though, is that you and Mr. Schmidt can't, y'all don't have that attorney-client relationship anymore that's healthy to the point where you can communicate to Mr. Schmidt, where he can communicate to you, and that y'all can get on the same page with how to defend your case.
Legal insight. When a defendant fires their court-appointed attorney and claims they'll hire private counsel, without any proof, the judge gets stuck. Appointing new counsel delays the process, but proceeding without counsel risks a mistrial. It's a tightrope walk with legal consequences on both sides.
Okay, so that's what I'm hearing is the concern for you and Mr. Schmidt as an attorney and officer of the court has brought it to my attention that you don't want him anymore. And so he's asking the court to allow him to withdraw as your attorney. And my only question is once I allow Mr. Schmidt to withdraw, then you don't have an attorney. And that concerns me because now you're by yourself and we're supposed to be moving forward with your case and you won't have an attorney representing you. That's why I'm asking, who is it that you're talking to so that I know that you're being represented?
Do you want me to look on my phone?
Do you on your phone, do you have
My
it?
phone's outside.
No, that's okay. That's okay. So you're telling me that if I allow Mr. Schmidt to withdraw, that you're going to hire an attorney?
Yes, sir.
Okay. All right, Mr. Schmidt, then I will reconsider at this time your motion to withdraw as counsel, and the court will grant your motion to withdraw, and you are removed from Mr. Gerard's case at his request.
Thank you.
And I'm doing that, and I'm not appointing counsel for Mr. Gerard at this time. He's been found to be indigent at this time. However, at his request to hire an attorney, I'm not going to appoint you an attorney at this time. I'm instead going to reset your case and give you time to hire your attorney.
Yes.
All right. So we're going to reset the docket call to March 7th. So that's 30 days.
30 days.
That's 30 days. Okay.
And on the reset, we're coming back for a docket call?
We're coming back for a docket call and competency evaluation, all of that.
Okay.
The status on that.
Okay.
But everything that we were set for today, we'll discuss again on the 7th.
All right.
All right. Now there's one other, Mr. Schmidt, that's all. You're excused. The only other issue I have, Mr. Gerard, is that I asked pre-trial release, I asked Mr. Waddell to get a UA sample from you
He
today.
got you from me already.
And he told me that it,
And here we go, the great urine debate. The court says, invalid, he says, I passed. Folks, this isn't a home drug test, it's official procedure. If the sample's not secure, it's not credible. The law runs on documentation, not declarations.
you're going to be subjected to urinalysis exams anytime that I say,
And I just took your analysis exam and that's,
I understand. He says that it's insufficient.
I don't know how to say sufficient. I just went up there and took
It
your
does-
analysis and passed it.
It doesn't matter what you think. It
Matter of
matters.
fact, I have an EEG board on my head and I'm gonna send you the video of me passing that UA.
Okay, that's fine. But I'm going to want you to give another one. Okay? If you pass the first
Okay.
one, you'll pass the second one. Okay?
I will, and I will send my lawyer up here to see you because I did pass that UA.
Well, your lawyer's supposed
I
to
took
come in
it.
to see me anyway. 'Cause
Yes.
that's part of
Legal meltdown alert. When courtroom arguments turn into conspiracy monologues about electronic signals, EEG boards, and ruined estates, it's less about defense and more about discrediting the process. This is where reality and legal narrative begin to split like a bad plea deal.
We have lawsuits against you because my estate is ruined from y'all locking me up for 8 months.
That's
And I'm leaving my doors unlocked, 26 unlocked doors at my estate, and my roof is falling in, and they stole all my cars, stole all my titles, stole all my, excuse me, sir. Excuse me. Y'all have lawsuits coming from us. Y'all have ruined our state. Your electronic monitoring system has been on for 10 years. 10 years. I can catch it with my EEG board and my security system. I'm a federal testing site. It says Van Zandt County Sheriff's Department and annex buildings signals on my head for 10 years straight. It's annoying. It's a mess. And it's injustice. And I'm suing everybody.
That's fine.
I'm suing from the top down. So you can do all your little authority and all that stuff. Get that electronic monitoring system off my head. Quit talking into my skull with that B2K, whatever y'all call it. Got me?
Yes, sir.
Yes, sir.
Clear.
Yes, sir. Thank you. That's what the auditory hallucinations and the little expert stuff is amounting to. I'm not crazy. I have that.
Understand.
I have that surveillance.
Understand. And no one's saying that you're crazy.
Yes.
No one's saying
Thank
that.
you.
I'm just saying that I
I'm
need.
gonna send you the video,
Okay,
but I'm really gonna show you in court when I see you.
that's fine.
Get it off my head, please.
I will.
Thank you, sir.
That's fine. But listen, I need you to take the other test. And so,
I need you to get the electronic monitoring system from Van Zandt County Sheriff's Department annex building off my head.
okay, but you gotta
Can you
go,
tell them?
you gotta go give, are you gonna give me a
You
test?
need to get that one and get it off my head.
Mr.
You
George,
need to get the one for the electronic monitoring system, get it off my head.
Mr. George,
Yes,
listen,
sir.
are you gonna give me another test?
Yes, sir. I will give you another test. Thank you.
Okay,
Do I have anything to sign?
no, not right now.
Okay.
Step out.
Electronic monitoring, so we have tasks. Electronic monitoring is in the Van Zandt County Sheriff's Department annex building, all property garage state.
Yes, sir. Go
Thank you, sir.
Go outside and see Mr. Waddell.
Thank you.
Give me that test and then come back in and have a seat, okay?
What do you mean I need to?
Because I haven't done your resetting, we haven't done your date. I gotta give you all that to sign.
67 years old, she's been sitting here for 10 hours.
I don't think she's missing.
Mr. Waddell, can you bring Mr. Waddell and tell me why it's insufficient? Can you tell me why it's insufficient? Because I peed and he said it was good.
Understand? I'm telling you, I want you to give another one because I believe it to be insufficient, okay?
Okay, listen, Mr. Waddell, it's insufficient on my test. Because you said it was a good specimen. I don't believe it. You don't believe it was my urine? I peed right in front of us. I peed right in front of you. Handed me the cup, you took your cup out, I peed right in front of you. I couldn't see. No, you were standing right here. Listen, no, see that is.
Listen, and listen,
You were standing right beside
Mr. Gerard, listen, Mr. Waddell, Mr. Gerard,
I feel like you're trying to lock me up.
listen,
Are you trying to lock me up?
not trying to lock you up. I want you to give another
You
scene.
consider my surveillance because you have that electronic monitoring system from his office for 10 years straight. Van Zandt County Sheriff's Department, is that right beside the adult probation office?
All
Is
right,
that the building right beside the adult probation office? Yes. All right, so that signal's been on my head for 10 years. Get it off my head. Thank you.
all right. So Mr. Gerard, go with Mr.
So
Waddell.
that's, you get your warrant trade if you're gonna stalk me around the world and ruin my house.
Mr. Gerard, I want you to go give him another urine sample, okay?
Come on. Come on, listen, I heard you.
Chad.
No, I'm not leaving my focus.
And just like that, game over. Refusing a court-ordered urinalysis equals direct contempt. No matter what your defense is, you cannot refuse compliance and expect freedom. When the judge says, custody, it's not a discussion. It's an order.